Good afternoon. My name is Greg Buck, and I am here to summarize the issues for the hearings that are about to take place in about an hour upstairs. This afternoon, we're asking a Hennepin County judge to consider asking for a restraining order based on the following facts. We believe that the Secretary of State, through his election judge guide, has directed election judges to provide ballots to ineligible voters. We believe that the Secretary of State knows that he's doing this, and we're simply asking the court to tell the Secretary of State to stop.
We're trying to keep it easy.
Now, for a little bit more in-depth discussion of the legal issues involved, I'd like to introduce Eric Cardle, who will speak to the legal issues.
Can you say and spell your name, please?
Yes, my name is Eric Cardle, E-R-I-C-K-K-A-A-R-D-A-L, and I'm the lawyer representing the Minnesota Voters Alliance in Ramsey County District Court today. And my clients are 3 election judges and the Minnesota Voters Alliance, and then a former candidate, Kirk Stensrud. And these clients are seeking a very narrowly tailored court order today. The narrowly tailored court order would basically say from the Ramsey County District Court judge that the 2016 Secretary of State Election Judges Guide at pages 14 and 15 entitle ineligible persons to vote. And so we're asking the court to enjoin election judges throughout the state of Minnesota to not provide a ballot to these ineligible persons on the precinct roster. Very narrowly tailored, very simple. Now, how we got here is quite a long story. About 5 months ago in June, we filed a petition with the Minnesota Supreme Court, an errors and omissions petition. It was delivered to the Secretary of State. So there have been 5 months for the Secretary of State to correct this error, this imprecision in his election judge guide, but he's failed to do so. And so today we're in court, and we're going to get a court order where the judge tells election judges, no longer in Minnesota are we going to give ballots to ineligible voters. Now you might say, how big a problem is this? Well, we looked, and we've been looking at who's voting while designated ineligible on the precinct rosters. And every time that it was crossed out, felony challenge citizenship, challenge guardianship, we found that it was an ineligible voter, not an eligible voter. We never found one instance where an eligible person was marked ineligible, which is great. Everyone agrees that no eligible person should be marked ineligible on the roster. In fact, the Secretary of State, through Gary Poser, the Minnesota Director of Elections, has said these people are double, triple vetted. That's fantastic. That means that all people marked on the precinct roster, according to the election guide, you're supposed to give them a ballot, but they're ineligible. So we're only talking about stopping ineligible people from voting. That's good. That's what the law requires. The Minnesota statutes involved in this case, particularly Minnesota Statute 204C12, are good statutes. Our legislature has passed good statutes. 204C12 is a good statute that allows challenges of eligibility based on residency and so forth. It's not a way to allow ineligible people to vote. That exceeds the authority of the Secretary of State. We're not challenging statutes. We're challenging the 2016 Election Judge Guide, which requires an election judge to give a ballot to an ineligible voter. Mr. Poser, in an email sent out to election judges November 2nd, indicated that 204C12 requires him to tell the election judges to give ballots to ineligible voters. That's hogwash. The 2016 Election Judge Guide goes beyond 204C12 and exceeds the Secretary of State's authority. It's illegal. So the reason why we have hundreds and hundreds and hundreds of convictions of felons voting is because the Secretary of State has an illegal policy that requires election judges to give ineligible felons ballots. The plain meaning of 204C12 provides for only new challenges on election day based on personal knowledge. Anyone would read 204C12, you would see that it's a chance for someone who knows that someone's marked eligible is ineligible. So a voter comes and say, as personal knowledge, they can challenge on election day that a person is ineligible. Prior to the election, there are ample opportunities for people who are marked ineligible to change it to eligibility if the documents show that. For example, the Secretary of State receives information from the court system and from the Department of Corrections regarding ineligible felons. They're marked challenged. So prior to the election, an ineligible felon can go to the Department of Corrections, can go to the court, and can change a mistake. The people who end up marked as ineligible on the precinct roster on election day are those people who have not exercised those challenges. So why would the 2016 election guide indicate give them a ballot if they self-certify verbally that they're eligible? This isn't loving your neighbor, facilitating through the election judge guide felonies by felons. You have violations of probation orders, you have violations of their parole. It's all bad. We don't want felonious voting in Minnesota. Stop the felonies, and the only way to do that is to stop the election judge guide. The election judge guide is a written policy that violates 204C12. Allowing people already to turn ineligible is an absurd result. Imagine, these are felons. They're ineligible to vote, and we're allowing them to self-certify their eligibility verbally? No. They have to go back to court, go back to the court administrator, go back to the Department of Corrections and get it fixed. The Secretary of State, through Gary Poser's November 2nd document, has admitted many things that are important to note. First, he admitted that basically by his silence, that the Department of Corrections, Minnesota court system, and Department Motor Vehicle reports on felons, wards, and non-citizens are accurate. Prior in the litigation, they were saying, oh, it's the other state agency's fault. But in the context of this litigation, they've abandoned that argument. When you see a shape changer like that, you know there's an element of dishonesty. Now they're saying we get accurate reports, but there might be some errors downstream. So that contradicts the fact that everyone knows there's double or triple vetting. There isn't one historical incident, not one, where someone has come forward and said, I was eligible and marked ineligible on the roster. Not a one. And you would think with this policy in place for many years, more than 5 years, that would be the case. Finally, the jurisdiction exists in the Ramsey County District Court to resolve this dispute. It's really sad that the Secretary of State and these election official managers are saying, we don't need oversight. We don't need judicial oversight. I'm a lawyer. I'm telling you that when the courts hold the government accountable to law, it redeems the system. It's not a bad thing. It's a good thing when election officials are held accountable to election law. And so today, we hope that the court says yes, under the process of a common law writ of quo warranto, or a statutory Chapter 586 writ of mandamus, or under the Chapter 555 declaratory judgment action, or under the Minnesota's election contest statute, the errors and omissions statute, Minnesota 204B.44. Somewhere in there, there's jurisdiction. You know why I know that? It's because on September 28th, the Minnesota Supreme Court issued a unanimous, per curiam, that means everyone co-authored it, published opinion which said this errors and omissions petition, the exact same issues we're dealing with today, should be heard in district court first. So why would the Minnesota Supreme Court publish a decision saying you should go get your remedies in district court if there weren't jurisdiction here? After all, we're talking about the government. The Minnesota Supreme Court is part of the government. The Ramsey County District Court is part of the government. The Secretary of State is part of the government. So where do we get our judicial oversight? We get it here and we get it today. Thank you.
You're asking for
any further questions?
Do you believe that it's reasonable for the judge to rule on this today?
Yes, because there are several instances, even this past week, in the November 2 memo where Mr. Poser, the Minnesota Director of Elections, sent an email out changing the procedures at the polling place. Previously, Mary Kiffmeyer, per an affidavit, sent out on the day of election a new way to handle, with respect to proving residency, cell phone bills. And there are other examples where, and another example would be the Secretary of State issued a policy a couple days before the election, I believe it was 2012, regarding election day apparel, what's allowed to be worn, what's not. And so there's several instances where changes have been made on election day or right previous to election day, and this would be one of those cases. We don't want this to seep into post-election challenges. There are going to be close elections, and we don't want this issue to come up. So we're trying to prevent a harm because everyone agrees that ineligible people shouldn't be allowed to vote.
You're asking for a change in the current election,
Yes, we're asking for a change before November 8th.
which is how many thousand people have already voted?
But this is different because those people are vetted. We're talking about the precinct rosters, and the election judge guide applies to the precinct rosters. So this involves the election judges. It's a different issue. It's a very narrowly tailored. It's just one issue, and that is the election judge guide requires an election ballot to be given on election day by the election judge to an ineligible person.
Do you have any idea how many ineligible felons there are on the roster now?
All the people given ballots under this policy have been ineligible.
Do you have any idea how many?
If there is one, it is too many. And we would have a better answer for that question, and it's a very good question. We'd have a very good answer for that if the Secretary of State would release the data to us, which he's refused to do.
How long ago did you ask for that data?
That was some number of years ago, 3 years.
Several times, most recently in 2015. And with respect to the answer to the question, we set our volunteers and hired staff on that question, and we went through the court records to see if these people who were being given ballots as they're ineligible, if any of them were eligible. And we found 1,700 instances of this, and every voter who voted, was given a ballot under this policy, was ineligible. So there has been one person found 1,700 times. Not one of those persons was eligible.
Do you have that record? Do you have that data?
Yeah, it's been submitted to the court, and it's found. In fact, the margin of victory in the Coleman-Franken race, there were 700, I think, ineligible felons we found, and the margin of victory was 312 votes.
So you're going to be submitting that data through the courts?
That's right. Then I think one of the bigger issues is regarding non-citizens. If you look at page 14 of the Election Judges Guide, it has these categories: challenge felony. And can you believe it? On the challenge felony, it says they may have committed a felony. No, they're ineligible. Under challenge guardianship, they may be under court order. No, they're ineligible. And then under citizenship, they couldn't even do that. See how clever this is? Because when these people are identified on their motor vehicle license, the driver's license, as status update, status challenge, they're noted as ineligible from the Department of Motor Vehicles to the Secretary of State. But they couldn't be challenged citizenship, but that's actually what's on the roster. But they couldn't describe it on page 14 because they never had the right to vote. But yet the question on page 15 is, are you a citizen? So in Minnesota, on election day registration, if you're a non-citizen and you go in and you say I'm a citizen, your vote counts. And then they tell us, oh, that can be challenged later through prosecution. No, the vote counts because we don't have provisional ballots.
Do you disagree with Justice Anderson's comments in the paper yesterday? Supreme Court Justice Anderson?
Yes, I disagree with him because if you want to have the best election system in the world, you have to work at it. And here, you have to have judicial accountability to work at it. And so we found this huge hole, and we told the Secretary of State in June, there's a huge problem here in that your policy actually tells the election judges to provide ballots to ineligible persons. And we've got all the evidence, all the documents, it all lays out fine, and we should get our order today. And the great thing about the order is it's a beginning of a process to have a better election system. There's no anti-government point here. We're just trying to get a court order to get this part fixed. And of course, there are many other parts that need to be fixed. But this Election Judge Guide, 2016 Election Judge Guide, is in error because it exceeds the authority of 204C12. Now, I want to tell you this. This is not an example of me being a good lawyer. 300 election judges have contacted me through signing this petition, and it's the election judges that brought the issue. This is a big problem. So these arguments are accessible. The election judges know this. There's not one election judge, not one, who has come forward with an affidavit supporting the Secretary of State. So do you go with the 3 election judges, or do you go with 0? I mean, 0 election judges would agree with this, because if I sat down with them, and they've already know it, they would agree with me.
You mean the 300?
No, everyone. Everyone would agree. No one's going to disagree that you can't have ineligible persons vote. I would ask anyone in the crowd to say, who thinks ineligible people should vote? No one thinks ineligible people should vote, yet this policy actually requires the election judges to allow ineligible persons to vote. So basically, Mr. Justice Anderson, I really admire him, And he's right, but he would agree with me that it's a long, arduous process to keep a good election system. And there can be mistakes made, mutual mistakes made. People can intentionally deviate from the standard. I don't know. But here, we're starting today to get a better election system.
Just to clarify something from earlier, it sounds as though this is not resolved today. You're ready and prepared to pounce on any recount situation post-election to bolster this argument?
Well, the argument, in a sense, isn't new. Coleman raised it through his attorneys. Emmer raised it through his attorneys. Local candidates in close elections have raised it through their attorneys. But the problem is the ineligible person's votes are already counted. They can't be clawed back. And so now what we're going to do is at least we pre-election have done everything we can do, and post-election we'll deal with the post-election contests. And then further, this litigation itself will continue beyond the election to clean it up for 2018.
Is the state arguing that this court has no jurisdiction in this case?
Yes, the Secretary of State is arguing, like King George, that they're immune from lawsuits. And so they're basically saying we're immune from all lawsuits in district court. We don't want no judicial oversight. And so we've responded by arguing the 4 possible bases for jurisdiction. And then what we've done is we point out that the September 28, 2016 Minnesota Supreme Court case pointed us to district court and suggested that it had jurisdiction. Of course, we have to respect the district court, but the district court has the Supreme Court opinion, and I think the district court will find it has jurisdiction because we need judicial oversight, not only over all state officials, including the Secretary of State.
What do you think about the Secretary of State threatening the election judges with being fired or criminal charges being brought against them?
Well, that's wrong. When there's an issue like this, the Secretary of State should sit down, just like these 300 election judges, and say, oh, I should change the policy. Rather, he's doubled down, tripled down, quadrupled down, and now he's saying he's going to dismiss these election judges or maybe prosecute them. And I think it would have been better for him to do his homework.
Well, he's saying that they have to execute the oath to follow the policy, otherwise they can't be a judge. As far as I know, he's not dismissing anyone.
And the oath requires the election judges to follow
State
Minnesota
law.
Yes.
State law.
And we believe that the Secretary of State's election judge guide is in violation of Minnesota election law.
So basically what it comes down to, one way to summarize it, is the Secretary of State can't mean it, that if his policy leads to the commission of felonies, that we have to participate in that system. And so it's a felony to vote while you're ineligible, and his policy requires the election judge to give ineligible persons ballots, which is a felony. So
we believe that the judge is going to rule in our favor, and the peril for any election judges is really minimal. Eric, I'm stepping out a little bit beyond my authority here, but I think it's that threat of dismissal is a little bit of puffery, because the head judge can always reassign the judge to hand out I voted stickers.